and welcome to the program on this Australia Day. First tonight, another twist in one of South Australia's most intriguing murder cases. Now, when our former chief forensic pathologist admitted to scientific errors and even contradicted his own sworn evidence, it seemed that at last there'd be a breakthrough in the Henry Keogh case. But 2 years on, in an extraordinary outcome, the Medical Tribunal is now backing his work. Graham Archer watched the drama unfold.
I expected that the district court, on the basis of the evidence that they had available to them, would come to a finding of unprofessional conduct against Dr Manock.
And they didn't.
And they didn't know.
The state's Medical Tribunal has just given the tick of approval to former forensic pathologist Dr Colin Manock's work in the autopsy of Anna-Jane Cheney in the Henry Keogh case.
Forensic experts from other jurisdictions will look upon this as a ridiculous situation.
The tribunal of lay panelists, along with District Court Judge Dean Clayton, set about assessing the specialised field of forensic pathology after a complaint of unprofessional conduct was laid by the medical board 2 years ago.
Of course, the function of the tribunal is to ensure proper procedures.
Dr Bob Moles has just co-authored a book with international experts on the obligations of forensic pathologists. In his view, the findings contain a fundamental flaw in endorsing Dr Manock's conduct.
They acknowledged in their judgment that he had made a significant number of, there were a significant number of deficiencies in the way in which he went about the work on this case, but that it didn't really matter because his answer was correct.
How could they possibly know?
The essential principle is, of course, that you can't know if the answer is correct unless you have gone through the correct procedure.
These findings need to be assessed knowing that since the Cheney autopsy came under question a decade ago, our authorities have steadfastly refused to take into account Dr Manock's previous record.
I rushed him to the hospital. I was just screaming, he's dead, he's dead, he's dead, all the way there. I knew it. He was just so blue.
The anguish which goes with babies being battered to death was magnified immeasurably when he concluded that despite their horrific injuries, the deaths of 3 infants in the early 90s were all due to natural causes.
He was just such a happy baby. He didn't deserve to die the way he died.
Dr Manock's misdiagnosis meant no prosecutions could ever proceed, with the coroner noting that
Dr Manock's autopsies had achieved the opposite of their purpose by closing off lines of further investigation rather than opening them up.
However, these damning findings were withheld, allowing Dr Manock to present his flawed science one last time in the Henry Keogh case.
You can't possibly evaluate claims about competence in an individual case unless you can actually see it in the context of a history of alleged incompetence and judicial findings which say as much.
This history of ineptitude is hardly surprising, given Dr Manock was never properly qualified for the job. Those who originally recruited him admitted as much.
He was unable to do certifying of the cause of death because of his lack in histopathology. We had a man who had no specialist qualifications doing a specialist job.
In the 3 decades he spent as our chief forensic pathologist, he never undertook the required 5 years of specialist study. Over the years, the enormity of this scandal has been steadfastly ignored or excused.
Why has there been such reluctance?
Plainly because of the potential embarrassment to the institutions in South Australia. I've done extensive research in Britain and in Canada, and there are no cases that would compare with this.
But even putting aside his error-riddled past, Dr Manock's most recent evidence to this tribunal should have sealed his fate. For starters, he seemed almost smug about his basic level of training, declaring at one point,
"I'm quite prepared to accept what my boss told me way back in 1962 or 63.
More importantly, he confessed to numerous errors, even admitting the very basis for his claims of murder in the Keogh case was scientifically invalid. During the trials, he'd wrongly claimed,
If a blow is sufficient to cause loss of consciousness, it's sufficient to leave some trace of bruising.
and because Anna-Jane showed no injury to the brain, he argued she must have been conscious and therefore was deliberately drowned. He now says his conclusions were based on bad science.
Because there was no injury to the brain, is it just as possible that she was knocked unconscious from an accidental fall?
It's plainly open on the evidence to say that she could have slipped, banged her head on the wall, fallen into the bath, and that was how her death came about. And there's not a single scrap of evidence to put in against that now.
And he conceded his flawed science had influenced what he put to the court.
I think it obviously coloured my opinions at that time.
On the basis that Dr Manock has now accepted in sworn evidence before the tribunal that crucial evidence he gave to the court was wrong, that first of all would justify the overturning of the verdict in and of itself without anything else, and secondly, it would go to the very heart of Dr Manock's credibility.
You might think that alone would have sealed the matter, but there was more to come. The forensic expert put forward to support Dr Manock was Professor Alan Green, who entered Leeds Medical School with Manock back in 1956, though we're told they've had no contact since. On matters of science, such as conscious or unconscious drowning, Professor Green agreed with those critical of Dr Manock's original claims.
Well, you can be knocked out and not have any damage to the brain, so I have to agree with Professors Cordner and Thomas and the general view that has been put.
While other observations Green made seemed to suddenly stir Dr Manock's memory. Professor Green said if a person was conscious when drowned, their lungs would show the imprint of the ribs as they struggled to breathe. Ah, said Dr Manock, that's exactly what I saw. And when quizzed...
Was that significant in your view?
He replied,
Yes, most definitely.
and yet he'd never revealed this observation until this very moment.
So is there any reason why, if that was a significant fact, you wouldn't have recorded it?
I can't explain that.
Why not? And again, in conscious drowning cases, Professor Green said the lung tissue would feel like bubble wrap. Sure enough, that's how it felt to me, said Dr Manock, though again, he'd never raised this anywhere before.
You didn't describe this fact?
No, I didn't.
Nor make a note of that specific finding?
No.
Amazingly, the tribunal decided nothing obliged him to record these significant observations, although you have to wonder about the timing of his recall.
Given that Dr Manock's theory about conscious drowning was wrong on his own admission, he then came up with other observations that seemed to support an alternative theory to justify that. And there's no basis for that in the records, and there's no proper procedure that would support that.
In all, he introduced over 24 new facts. Yet, when he'd been asked at Keogh's trials about his original autopsy report...
Was that an accurate record of what you observed and did during the post-mortem examination?
Dr Manock's response on oath was...
Yes.
Was that a fair answer?
Well, plainly it's not, because Dr Manock has subsequently given sworn evidence on many occasions that shows that that was not correct.
None of this troubled the tribunal, who essentially considered his deficiencies to be trivial or harmless.
Really what they're saying is, well, it doesn't matter.
While the barrackers, wishing to keep this 30-year forensic fiasco in the closet, will see the tribunal's findings as a victory, in fact, it's yet another impediment to dealing with the fact that the autopsy findings of nearly 10,000 South Australian men, women and children were certified by a man not scientifically qualified to sign off on one. The tribunal result appears to further isolate the state from acceptable standards operating elsewhere.
It's totally out of kilter with decisions of the High Court of Australia, and it's totally out of kilter with the codes of professional conduct and practice manuals of forensic experts in the common law countries.
As such, presumably it could be appealed.
Absolutely, of course it could.
We'll just have to see if the medical board are prepared to have the courage of their convictions. Meanwhile, Dr Manock's claim in The Advertiser on his arrival in Adelaide in 1968 could hardly be more telling.
Before we submit any evidence to court, we have to be able to back it up with undisputed scientific proof.
He failed his own test, but passed the tribunals.
And in the course of history, people will look upon this as a very dark moment in both legal and forensic science history of South Australia.
Well, Graham Archer there. Now, in on the state of the nation, where we've been and where we're going.
There's record high net migration at the moment, well over 200,000 a year.
Our population is soaring faster than America, England and most of the developing countries, increasing by 1 person every 1 minute and 11 seconds. That's around 443,000 people every year. Now the alarm bells are ringing.
No one's ever done a study to see if we can cope with 40 million or even 100 million people, and that's the problem.
Dick Smith has shocked the nation by encouraging families to limit the amount of children they have to just 2. The former Australian of the Year warns our booming population could starve if allowed to grow recklessly.
People claim that we'll always have enough food and water